Grounds for divorce in BC. If you're considering divorce in British Columbia, it's important to understand the legal grounds and process involved. Today, let's break down what you need to know about divorce in BC. First, to get a divorce in BC, you must meet two key requirements: residency and grounds for divorce. At least one spouse must have lived in BC for at least 1 year before filing. And when it comes to grounds, the law is quite specific. The Supreme Court of BC follows the Federal Divorce Act, which recognizes only a few grounds for divorce. The most common, and practically the only ground used, is the irretrievable breakdown of the marriage. This is usually proven by showing that the couple has lived separate and apart for at least 1 year before filing. There are two other grounds: adultery and cruelty. However, these are rarely used because they can be difficult to prove. They also tend to make the process more adversarial, longer, and more expensive. That's why most divorces in BC are no-fault divorces, based simply on 12 months of separation. Separation for many people means living in different homes, but this is not always the case. You can be considered separated if you live separate lives financially, socially, and romantically, even under the same roof. No-fault divorces are encouraged because they save court time, reduce conflict, and are less costly. Courts may even order a spouse to pay costs if they insist on claiming adultery or cruelty without strong evidence. Now, what about prenuptial agreements? These can influence your divorce by clarifying financial matters up front. They often help speed up the process and reduce disputes over property or support. Speaking of costs, court expenses can affect how couples approach divorce. Many try to avoid lengthy battles to minimize legal fees and potential cost awards. How long does a divorce take in BC? If it's uncontested and based on separation, you can file after 1 year apart. Then the court usually finalizes the divorce within a couple of months, assuming all issues are settled. If you reconcile and live together for less than 90 days, the separation clock keeps running. But if it's longer, you'll need to start the 1 year separation period over. Do you need a separation agreement? Not necessarily, but the court will want to see that all issues, especially those involving children, are resolved. A separation agreement formalizes these arrangements and often speeds up the divorce process. If your spouse won't cooperate, there are alternatives to court battle. Lawyers can negotiate on your behalf, or you can try mediation or arbitration. These methods are usually less stressful and costly than litigation. At Spectrum Family Law, we serve the entire provinces of Alberta and BC with multiple offices where we're able to meet in person or virtually. Click the Get Help link in the description for our dedicated intake form to help you get the ball rolling. Our intake team will review your specific case and advise you on the next steps to take. If you found this video helpful, please hit the like button. If you're interested in learning more about family law, hit subscribe. Thanks for watching!